Hi everyone, in this video I'm going to answer your latest questions. This is the 13th session that we've done of these question answers, so without further ado I'll move on to the first question. Apart from waiting for the CCRC to refer this to the Court of Appeal, is there anything else that unlocks this? Well, there are other options theoretically available. I wouldn't hold out too much hope for any of those options because, for example, there can be a political resolution in extreme circumstances. There can be various ways that Lucy is pardoned, but that's just not going to happen. You've seen the kind of resistance of, for example, Wes Streeting to doing anything else other than say that the system is always correct. And politicians will typically not speak out about court cases. There are instances, contrary to what is claimed, there are instances where the government does interfere in the judicial process and the legal process, even though they claim not to. But they're not going to do it over one nurse. There'd have to be extraordinary circumstances, and indeed most MPs, I think, are warned not to speak out against the courts, and it takes very senior MPs like Sir Jeremy Hunt and Sir David Davis to do this. So I wouldn't hold out too much hope for anything other than the legal route, unfortunately. Hey Chris, off topic, but can you tell me if Dr. Bohin reviewed Evan's notes, or did she actually read the baby's medical files and just agreed with him? Thanks. So we know for a fact that Dr. Bohin read all of Dr. Evans' reports. In fact, she said when speaking to Liz Hull and Caroline Cheetham that she read all of the reports before she did anything else. So that pretty much answers the question definitively. Of course, this shouldn't have happened. Was everyone connected with the case, defence, prosecution and maybe even the police, surprised at the guilty verdicts? Of course, this requires a degree of speculation from myself, but I don't think they were surprised. It's hard to comment about the defence. The defence obviously looks at a lot of information pointing to it being an unsafe conviction or innocent, so they may have a different outlook. I don't think the prosecution cares. The prosecution is just there to prosecute and there to win. They ultimately don't care about the verdicts. I think the police would not be surprised at all because they were fully invested in the idea that Lucy Letby was guilty. They're still invested in that idea today, although there must be more doubts by this point. But I think when Lucy Letby was convicted, they didn't doubt for 1 second that they were correct, and they didn't doubt for 1 second that they'd done an incredible investigation. Of course, we know now that they weren't correct, and they hadn't done an incredible investigation, but I don't think that they questioned or doubted themselves at all. Could Lucy sue Dr. Evans and the doctors and police for failings and withholding evidence from the defence? She should also consider suing her first defence team as they were awful. Theoretically, yes. Anyone can sue anyone, essentially. All you need is a willing lawyer to go to court. You don't even need a willing lawyer. You can represent yourself. Ideally, you'd get a legal professional. But in a case of libel, anyone could claim anything. Of course, if you make frivolous claims, you will lose a lot of money. In this case, firstly, she'd have to be advised that she had a legitimate case, and then secondly, I can't see Lucy voluntarily going into a courtroom. I don't think this is a good idea for her. I think she needs to process this and move on, and we need to do everything possible to make sure that she's financially secure. I don't think she should go into a courtroom again and drag this all up again unless it's going to help her or be cathartic. And I certainly don't think a courtroom is the right place for her to do this, so I think it's unbelievably unlikely that she'd want to do this. Lucy's case has emphasised a real degrading put-down and general disregard for nurses, which is insulting, considering that we are degreed, dedicated healthcare professionals, evidencing best practice and accountability. The police and prosecution team have shown us no credible respect. Why? Well, firstly, I completely agree with your assertion that there has been a general disregard for nurses and nursing in the debacle of this conviction. So the question, therefore, is why has this happened? So I think you could really give a very long answer to this question, but I think a lot of it just comes from kind of inbuilt attitudes that we have, that not everyone has these attitudes, but that are somewhat prevalent, or I would say very prevalent even, societally, and only kind of questioning particularly thoughtful and intelligent people can question their own cognitive biases. Even then, everyone is subject and vulnerable to cognitive biases. Certainly, people of the intelligence of Hughes, Stonier, and Blackwell are vulnerable to cognitive biases. What are these cognitive biases? I think, firstly, there is a major issue of classism in this case, whereby you're talking about upper middle class consultants being believed over a lower status nurse. And I do think, I've discussed this with Lulu on the channel, I do think there's an element of sexism in this case and misogyny. I don't think it's as strong as the classism, because male nurses have been convicted as well. So obviously there wasn't any misogyny there. But I do think it is almost without exception male middle class, upper middle class consultants being believed over a lower class female nurse. And I think that goes very deeply into a lot of quite ingrained elements of British society. I've mentioned before that I explained to my American friend that I gave her the example of Fawlty Towers, and I said to her, "Have you seen that?" She said yes. And I said, "Notice how Basil Fawlty obviously depicted as being a bad person, but a plausible person, and even at times someone that we can understand and relate to, not someone who's entirely unrelatable. He will just bully underlings and treat them like absolute crap, but then he'll try and ingratiate himself with people that he sees of higher social status and higher social class. And I think things have evolved slightly, or maybe even significantly from that era, which was 50 years ago. That was the society that I grew up in, basically. Things have evolved, but I think those inbuilt classism and that inbuilt class consciousness is still very much part of our society. And then the other reason is I think people are quite ignorant, actually, about the level of medical knowledge that nurses have. I hope that I didn't come into this case ignorant, but I do think at the same time I perhaps didn't quite realise the extent of it. So I think there's a process of education regarding what nurses actually do, because I think it is still seen primarily as a caring profession and secondly as a medical profession, when it should be seen as both of those elements being of equal importance. So I think the general disregard for nursing and the way that Lucy was treated and so on and so forth, and the way this case worked out in court is a reflection of all of those things, and also is a reflection of some very ignorant people being involved in the conviction of Lucy Letby. Will Lucy get a copy of your book? It's quite likely that I'll send Lucy a copy and her parents. I think that would be a reasonable thing to do. Of course, if anyone else wants to send her a copy, then that would be appreciated if you want to do that. But I think it's likely that I haven't had any contact with Lucy. I haven't had any contact with her parents. I haven't had time, apart from anything else. But I also kind of made a conscious decision not to contact Lucy. But I will be writing to her parents, and it's likely that I'll write to her. It's really a courtesy just to say, look, I've written a book about you, and for her parents to say I've written a book about Lucy, and just to inform them that there could be some media coverage, or it certainly is likely to get a certain degree of attention. So yeah, it's likely I'll send a copy. I haven't 100% decided, but probably I will. But if other people wish to send one, then that's absolutely fine. I thought the reason Mike Hall wasn't called was because he had deferred to the prosecution's opinion on the insulin cases. So all I will say regarding this is that there's more information on this issue in my book that I can't reveal at this point in time, but this point is addressed fully in a way that hasn't been addressed previously and in some detail. Just a thought, has there ever or anywhere been a public inquiry about something that didn't happen? So, of course, I can't definitively answer this question because I don't know. I think it's very likely that there could have been a public inquiry at some point about something that didn't happen the way that it was reported, or something that maybe didn't happen at all. I wonder if there's been a public inquiry into UFO sightings or something like that. Not that I'm saying it's impossible for a UFO to land here, but I think it's fair to say that some UFO sightings are not alien spacecraft? I don't know. I can't answer that question, but what I can say is that the Thirlwall inquiry has been a fairly extraordinary public inquiry, as investigating something that didn't happen and assuming that the crimes that didn't occur are sacrosanct. And that's why Lady Thirlwall is now in such a very difficult position, of course. I'm speaking very ignorantly, I expect here, but am I right in understanding that Lucy would have had to speak under oath that everything she said was the whole truth, etc., but prosecutors such as Dewi Evans would not have to? No, that's not true. Everyone who speaks in court has to swear a solemn oath, and they swear to tell the truth, the whole truth, and nothing but the truth. That applies to anyone that speaks in court. So that's not correct. I am confused about what exactly Dr. Evans' role was at trial, because he's actually on record denying that he was an expert witness. That's true. During cross-examination concerning the death of baby A, he stated, "I call myself an independent medical witness, not an expert." So, I'll deal with that firstly. So this is just an example of Dr. Evans' kind of self-regard, I would describe it as. It's not up to him to define his role in the court. He is an expert witness. That's why he's there. It doesn't matter that he calls himself an independent medical witness. It's irrelevant. But this would have been while the prosecution was speaking with him, and they wouldn't have corrected this because he's there to be their witness and they're trying to make him sound independent. Of course, he's anything but. This is because we can say that, but there shouldn't be a situation where you're involved with the police investigation and then you give expert witness evidence in court. This has been stated many times. It's clearly yet another weakness of the system. So he's there trying to say, "Oh, look, I'm really independent." But it's really not his place. It shouldn't be his place to define that. It should be the system's place to define that. Unfortunately, he is entitled to be involved in the investigation and then give quote-unquote expert witness evidence as well. So to continue with the comment, this is very confusing because Dr. Evans was not being called on by the prosecution to give evidence as a witness of fact. This was the trial of a criminal case against Lucy Letby, not an inquiry into the police investigation itself. Just to be clear, medical doctors often are called as witnesses of fact in all sorts of legal cases, including criminal trials, where they can give factual evidence or some interpretation of evidence relevant to the trial. This is common where someone concerned with the case is or was a patient of the doctor. In this capacity, the doctor is acting as a professional witness, which is a type of witness of fact. Is this what Dr. Evans means, so that he was a professional witness on behalf of the police? So no, it actually isn't, because he's not a witness of fact in the court case. He is there as an expert witness regardless of what he says. His view is essentially irrelevant. He is an expert witness. He's there in court as an expert witness. It doesn't matter what he says. It's just the kind of waffle and nonsense that he comes out with almost inevitably every time he says anything. The problem is that Dr. Evans did not treat any of the patients, therefore he was not in a position to provide first-hand evidence as would be expected from a witness of fact. That's absolutely correct, and that's why he's not a witness of fact. Cannot claim to be a witness of fact. He's an expert witness. It doesn't matter what he says. That was his role in the court case. Great input as ever, as much as I'm fully on board with poor Lucy being innocent, but all this seems to go on forever without any feedback on where we are getting with Lucy being released. When, how long, what is the timeline for this to happen? So I have discussed this previously, but I'm going to now go over this in some detail, so hopefully this will make this clear to people. So the first scenario is that one of the prosecution witnesses decides to remove the evidence from the court case, and public and political demand rapidly causes the case to collapse. This could feasibly happen this year or next year. I must say that this is phenomenally unlikely. All the prosecution witnesses have kept pretty quiet, apart from Evans and more recently Bohin, and they don't show any indication that they're going to remove their evidence from the court case, even though morally and ethically there's a strong argument for them doing this. So I don't for one second suppose that this will happen, but it is not completely impossible. A second scenario would be that the case is referred to the Court of Appeal fairly rapidly this year. The Court of Appeal addresses the case in a relatively short time frame, perhaps 6 to 8 months might be realistic. The case collapses, the system gets its arse into gear quickly and ensures that Lucy is released as soon as possible. This would see her released in 2027. Possibly it could be early 2028 as well. That's kind of covered by this scenario 3 as well, in which all that was previously mentioned in scenario 2 occurs, but there is a bigger delay in referring the case to the Court of Appeal. For example, in the case of Colin Campbell, it took 3 years for the Court of Appeal to hear his case, in which case the release date could be between 2023 and 2030, depending on various factors and various timescales. A fourth scenario is that there could be further delays to exoneration caused by the prosecution seeking a retrial. This could collapse before it reached court, but the timeline for this is uncertain, or of course the retrial could take place as well. So the release date then will be 2028 to 2031. Another option here, scenario 5, is that ultimately there is a retrial and Lucy Letby is exonerated. There are so many factors that affect the timeline here, it's very difficult to predict when this would happen. It could be as early as 2028. It's hard to see it occurring in 2027, but then it could drag on for several years as well. Release date 2028 to 2032. A sixth scenario is either the Criminal Cases Review Commission refuses to refer the case to the Court of Appeal, which in my view is highly unlikely, or the Court of Appeal upholds the conviction. I'm not sure how plausible the latter is, but it's certainly not impossible. In this scenario, we would need to keep fighting for Lucy's exoneration. It's very difficult to put a precise date on this. We just need to stay the course, whatever happens. Scenario 7, a fairly catastrophic scenario would be if Lucy was found guilty on one of the cases in her retrial. I'm not sure what hope she would have of an appeal under these circumstances. It's possible that her sentence would be less severe. I'm not really sure. It does seem highly unlikely that she would lose any of her cases in a retrial, but this cannot be ruled out completely. I just want to present this as a possible, if admittedly unlikely, scenario. I'm not sure under these circumstances that Lucy would ever be released from prison, and it certainly seems likely to me that she'd have to serve her whole sentence. So finally, I'm just going to show the 4 gradations of outcomes and possible timelines for Lucy's exoneration. So the first gradation is incredibly unlikely but best case scenario that it would be required for... I think the only way this could be triggered would be by one of the witnesses withdrawing their evidence. It's clear the police are not going to do this. It's clear the Crown Prosecution Service are not going to do this. So it would have to be one of the witnesses, and I just don't see that happening. But in that case, you could be exonerated very quickly. A more realistic scenario would be a quick response from the system. The case is tested in the Court of Appeal. It collapses, and Lucy is exonerated quickly. A good outcome, but still relatively delayed, would be a slower response from the system, possibly a retrial, and that would result in the release. When I made this image, unfortunately, I did it all 10 years wrong, which is pretty stupid. But you get confused because we're going back to dates that occurred in 2016 to 2017. I stupidly did it 2017, 2018 instead of 2027, 2028. But at the earliest, obviously, exoneration will be 2027, then 2028, and then this one will be 2029 to 2031. What this, of course, illustrates is that Lucy's suffered a 10-year nightmare. Even if she's exonerated today, it's been a 10-year nightmare. Obviously, that's not going to happen. So we're looking 10, 11, 12, 13, 14, 15 years she will have been going through this nightmare, with possible release 2029 to 2031 in this scenario. And then, of course, as I mentioned, she could possibly lose at the Court of Appeal or lose in court. Then the release would be pushed back even further. We're talking 2032 plus. We don't know how many more years. We don't even know if she'd beat a sentence. So all these outcomes are possible. I suspect scenario 2 or somewhere between scenario 2 and scenario 3 is the most likely. Hopefully, if things happen quickly, it could be within a couple of years, or it might be as much as 5 years. And that's just the reality. Public pressure can make a big difference. That's why I've written my book, why I've been working on this case, why I'm doing the best that I can to help. I hope that my book can make a difference. I just need your support with that. Public pressure is critical. It was absolutely critical in the case of the Birmingham 6. Otherwise, they'd still be in prison. So if you could just support me as much as possible when my book comes out, that would be very much appreciated. Can you ask Mark MacDonald if Netflix can be sued and under what legislation? Cheshire Police can be sued as well as individual police officers. There is cooperation between these two and even more. So very simple answer to this question. Anyone can be sued. Netflix can be sued. But their contract and what they did in this documentary will be absolutely watertight legally. They're a multi-billion-dollar company. they are literally one of the biggest companies in the world, certainly they're one of the biggest internet companies, that they'll be basically behind maybe Amazon, Google, Facebook, and no one else. So I guess online company, you might describe them more than internet, but there's just no prospect you could sue them successfully. They will have been... What they did can be described as unethical, but it won't be illegal, and it won't be libelous, and it won't be defamatory, and you would lose. You are right to point out how hamstrung politicians are today, but is it more than that? Is it the fact Keir Starmer used to be Director of Public Prosecutions relevant? He would not want everyone in the country questioning the entire judicial system, as would inevitably happen if Lucy were released. Could he be the worst possible Prime Minister to be in power, as Lucy seeks to have her conviction overturned? So, firstly, with regard to Keir Starmer being the Director of Public Prosecutions, this can be somewhat relevant, but I would argue that another Prime Minister would be unlikely to behave any differently. I think it's also true, in answer to your question, that Keir Starmer would not want everyone in the country questioning the entire judicial system, but again, that could be equally true of other governments. Typically, governments want the system to function unencumbered by public challenge because their power and their position of control, essentially, is entirely predicated on public acquiescence, because there's very, very many more of us than there is of people in positions of so-called power. So, of course, any government almost intrinsically wants people to believe in the judicial system, so I don't think that's necessarily more amplified in a administration or government that is headed by Keir Starmer. In terms of whether he's the worst possible Prime Minister, I doubt that we're streeting... Keir Starmer, it appears that his days are seriously numbered at this point. In that case, a likely incumbent would be Wes Streeting, and he will be absolutely no different to Keir Starmer. He's actually been more outspoken than Keir Starmer so far. So I'm not sure that, while I think you make some very reasonable points, I'm not sure in practice it actually makes that much difference that Keir Starmer is the Prime Minister. Will there be any investigation into Shaun Edwards' involvement/influence in the case? I suppose the short answer to this question is I don't know. It depends on whether the Criminal Cases Review Commission deems this to be necessary. You would think that there possibly should be some investigation, given that he'd made these very explicit comments online supporting the police, and then he's gone into seemingly been involved in the investigation of the CCRC, presumably hasn't revealed what he said previously. Now, we must assume that he acted in good faith. We don't know otherwise. Obviously, it's pretty embarrassing for the CCRC, and you would think that there should be some form of investigation. Whether that delays the case, whether it damages the case in any way, I don't know. I still expect the CCRC to refer this case to the Court of Appeal, completely regardless of the Shaun Edwards issue, but it does seem in the interest of transparency that there should be some sort of internal investigation and that should be made public. Can we get some info from someone who knows about how the CCRC goes about assessing a case? All I have found is that case officers present to 3 commissioners who then decide. The CCRC say they can bring in their own experts. I can see that there are a lot of submissions reports to go through, which is what could be taking the time. I understand the CCRC has to present justification for referral to the Court of Appeal, but you would think with the weight of professional opinion, medically, statistically, etc., that this in itself would be sufficient to refer the case. So I absolutely agree with the final sentence, and I do think the case will be referred. As you state yourself, they do have a lot of information to go through, and it is a reasonable defence for them to state, well, this takes a certain amount of time. They have attempted to pointedly note that it took a while to waive privilege, and that can be an issue as well in the delays. I mean, I knew that this would happen. I knew that privilege would be waived. I knew there was a red herring and a non-issue, as indeed proven to be. In terms about how the CCRC goes about assessing a case, they're not the most transparent organisation, so it's really not possible to obtain any more information than what you already understand yourself. They can bring in their own experts. They can commission their own reports, essentially. Whether or not that would happen, whether or not it would be plausible, I don't know. And they certainly couldn't... There's no chance they could get the same quality of experts as involved in the the panel reports, and they would not be of the same calibre, clearly. But that is something they can do. They can certainly refer to experts. They should refer to experts. Can this delay the case for a significant period of time? Yes. Will it do that or not? I have no idea. All I can say is that as I probably go more into the public domain, when my book is released, I'll be calling on them to make a swift decision. And I must emphasise that's why I wrote my book, is to help create this public pressure that will be needed for this case to be overturned and for that to happen expediently. If the CCRC takes another few years, will the Thirlwall inquiry keep deferring? This is a good question. It's one that, again, requires a degree of speculation, and any answer that I give can be incorrect. I think, given the recent statement, there was, again, very non-committal. There's supposed to be a time... I was going to say there's supposed to be timetable events, but this final recommendations report was supposed to have come out 8 months ago, in September last year. So it's very difficult to say precisely what happened. This is certainly an unusual degree of delay. And then they said there's going to be a timetable at the end of February. Now at the end of April, there's no timetable yet. It doesn't seem that there's an immediate prospect of the report being released. So there's quite significant evidence to suggest they're just going to defer until the CCRC refers the case and then say, oh, we can't do anything now. But I couldn't say that with any confidence, but it does seem a distinct possibility at this stage. Chris, I have a question for your next Q&A. How is your own mental health doing? I'm delighted to have an insight into the beautiful area where you live, and always reassured to see how energised you seem to be, but the wind/head bang against the wall ratio must be off the scale when combating such a Kafka-esque system. Firstly, thank you for asking this question. It's very thoughtful. I certainly agree with your excellent description of what it's like to be dealing with this. All I would say is that I came into this with my eyes wide open. I was fully aware of what it was going to be like, and I knew there would need to be a lot of determination from anyone that was going to be significantly involved. With regard to my own mental health, I do take what you might describe as precautions in relation to this. I do make sure that I spend some time in nature every day. Obviously, I spend a lot of time with Kiko, and I think she just doesn't allow your mental health to decline. I mean, she's so much fun to be around, and we share a lot of things together. And then, I've got a good group of friends, and I've met lots of people through this, and I do try and make a little bit of time to do something social. And I live in a nice place to begin with, and I'm fairly comfortable, I suppose. So, yeah, my mental health is fine, and I do take steps to ensure that it remains as such. But yeah, I appreciate the consideration, but for me, I knew I would need to be very determined, and I will just keep going and going and going for as long as it takes. What I will say is I'm looking forward to getting my book out there and then going through the immediate aftermath of that, and then hopefully I can have a little bit of a rest and just do YouTube for a bit, because it has been hard work, and I'm really enormously grateful for all the support. The time I'm reading this, recording this rather, we just went through 7,000 subscribers. I never expected to get anywhere near that. It's going up all the time, so yeah, I'm just really grateful for the support, and I do feel a sense of responsibility to keep going, and that's what I'll do. So you don't need to worry about me, but I do very much appreciate the concern. How was it that a very busy consultant, Brearey, who only had time to visit the neonatal unit twice per week instead of twice a day as expected, decided that a spike in deaths was due to one nurse committing murders? Why automatically believe the presence of a serial killer? Why become so obsessed with one nurse? So I'll answer these questions first before I read the rest of the post. Now, I could give a very long answer to this question. I think the first thing to say is that we will tend to have self-serving beliefs. That is a function of all human beings. Those of us that there are various personality traits and aspects of our character that can feed into this. I would say intelligence can make a difference, but there are lots of very self-serving, intelligent people, so I wouldn't necessarily say that's a significant factor. You have to be able to be aware of your own cognitive biases and be able to respond to them. Of course, we all have cognitive biases, so none of us is completely objective, but those of us that are more aware of our cognitive biases and those of us that feel morally or ethically we're incentivized to be aware of them and try to respond to them will be more inclined to do so. In this case, there isn't the same incentive for Dr. Brearey. We don't know that much about his character in terms of, I don't know him personally. I can only go on what I can observe from the Thirlwall inquiry documents. So I don't know what he's like as a person. I only know the way that he behaved, but he wouldn't be the first consultant in the world to think I am right about everything, and therefore if I decide that there's a serial killer nurse, then I'm obviously right because I'm a consultant and I'm Dr. Stephen Brearey. I don't know if that's true, but as I say, it wouldn't be enormously surprising if there was an element of truth in that. And then, of course, many people have observed, and we've seen with this recent grievance document, that his head was potentially on the chopping block, or at the very least, he could have faced serious professional problems. So that will then tend, whether consciously or subconsciously, to make you more sympathetic for what is already a self-serving position to take. So those are two things to consider immediately. I've had many people mention, and someone else mentioned this to me again the other day, someone very credible, that it's possible that there were pre-existing issues between Lucy and Brearey, regardless of whether Lucy knew this or not. I don't know whether this is true or not. We simply don't know, but there is a possibility this could have coloured his attitude towards Lucy. Another point that I'd like to raise is that I was looking up the other day, and the conviction of Victorino Chua, which was in Stotford Stepping Hill, that had only happened shortly before Stephen Brearey became, to use your terms, automatically believing in the presence of a serial killer. So that could have had a big influence on his thinking, again, whether consciously or subconsciously. We're not all aware of our cognitive biases. Even if we are aware of them, it can be difficult to stop them, particularly when there's a self-serving reason. So it seems at some point this idea that there could be a serial killer nurse, or there could be a nurse that was responsible, just gathered momentum, and then all other possibilities were sidelined, even though this was irrational. And what I've mentioned there are just a few potentially contributing factors to what occurred. The reality is we may never know why Dr. Stephen Brearey did what he did, and even Dr. Stephen Brearey may not be able to tell us. It can be for subconscious reasons, it can be for reasons of cognitive bias that he can't understand. Are we to believe his infatuation with her only came about as a result of him becoming acquainted with who was on duty at the time of collapses and deaths? So I've kind of addressed that. We don't know, but there's a possibility that that's not true. And yet he must surely have known that she was not present for all unexplained deaths, as we all know now. So what drove him to make his assertion with such unwavering certainty, we'll probably never know. I mean, I'm pretty certain we will never know. As mentioned, although he may have been aware that she wasn't there for all unexplained deaths, once a theory embedded itself, he may not have had the incentive, character, and ability to assess things rationally required to draw what would have been rational conclusions in this situation. Thanks, Chris. I like many, hope that both Brearey and Jayaram will soon spend time in court explaining their actions. Well, I can't guarantee that this will happen. It's hard to say whether it would happen or not. It's not beyond the realm of possibility. What I will say is that both Brearey and Jayaram will face scrutiny. They're not just going to be able to walk away and go, whoops, what a cock-up. Boy, our faces are red. Never mind, we'll just go back to our jobs now. They're going to face very serious scrutiny. What the consequences of that will be and what the exact form that scrutiny will take remains to be seen. But I can assure you they won't just walk away from this. The grievance would have been valuable evidence for the defence and independent examination of events, finding no grounds for complaint against Lucy. Some pennies take a long time to drop, at least with me, grounds for judicial misconduct in the CCRC application. So I think it's extremely difficult to prove judicial misconduct, something very, very serious, very, very obvious needs to occur. So the judge will have had his reasons for ruling it out. We may very well view this as unreasonable and unfair, as indeed I do, as I indeed do with regards to CCRC PCH report, as I do with allowing Dr. Evans to be in the court case. But whether he would have broken judicial regulations and procedures, policy, etc., highly doubtful. So I don't think there would be grounds for any kind of judicial misconduct there. It's just incredibly difficult to get the Court of Appeal or any body, any kind of prominent body associated with the criminal justice system, to get them to do or say something related to that. Is you've probably got a better chance of having afternoon tea with the Pope. It's going to be extremely difficult. I was a nurse for about 9 years, 6 full-time and 3 years part-time. I worked on a variety of wards and did a 3-year stint in operating theatres. I left nursing in 1988. Friction between doctors and nurses was common. Doctors having vendettas was common, and it sounds as though not much has changed. So the reason I read this comment out is because I just wanted to emphasise that we talk a lot about the NHS culture, but according to this person who's very much more experienced than me, this is nothing new. So if there were pre-existing issues between either Brearey and Lucy or another member of the consultants or the consultants collectively, that wouldn't be anything out of the ordinary, and it wouldn't be, certainly according to this poster, out of the ordinary for there to be friction and for there to be, as is described here, a vendetta. A theme running through all of this is poor leadership. Who was the ultimate decision maker here, and why was the board so ineffective in stating there is no evidence to support an allegation of murder? So I think what Ian Harvey and Tony Chambers were trying to do was keep everyone happy and manage things delicately, and they thought if they were engaged in diplomatic actions that the situation could be dealt with, it could be resolved, and Lucy could go onto the unit, the consultants could be kept happy, the nursing staff could be kept happy, Lucy could be kept happy, they could continue as a hospital with a neonatal unit, and the situation would be resolved without getting into the media, and so on and so forth. Another possible consideration is that Ian Harvey and Tony Chambers thought that they were potentially vulnerable if things blew up, and that's why they're trying to handle things very delicately. Now I want you to engage in a moment that will require a significant amount of imagination for a second, but I want you to imagine that Donald Trump was the manager at the Counter Chester after that grievance procedure had occurred. Now, he just would not stand for his authority being undermined or challenged. And I mean, I'm using this as a slightly facetious example, but someone who was willing to play hardball with the consultants would be armed with that piece of paper that said they should face disciplinary procedures. And this person would say to them, right, you've got 4 options. Go back to the unit, do your job and shut up. Phone the police yourself. Never mind pestering me all the time to phone the police. You phone the police if you're that bothered about it, and you put your own neck on the line. You've given me no evidence, so I've got no basis to go to the police. If you're so bothered, you go to the police. Thirdly, we can bring in an external body to conduct a medical investigation, but you will be held culpable with regard to any findings. And then your fourth option is, if you can't shut up, and if you can't do number 2, and if you can't do number 3, go and get a job somewhere else. If I hear any more problems, then we'll be taking disciplinary proceedings against you. I'm perfectly entitled to do that anyway. And that's what should have happened at that stage. As I say, I've explained the reasons why Ian Harvey and Tony Chambers didn't do this. They favoured a diplomatic approach. But as I say, if someone like Trump, someone of that personality type, was in that hospital, then at that point they could have played hardball with the consultants and just said, look, these are your 4 options. That's it. Don't keep coming crying to me and saying this, that and the other. I want you to do this, I want you to do that. Oh, we're not happy with this, we're not happy with that. You've just been found wanting, to say the least, by this grievance procedure. I can start disciplinary action against you tomorrow, and I will if you don't shut up. But they obviously didn't want to handle it that way, I think for obvious reasons. But that would have been the way that Lucy could have, I would never be sat here, we never would have heard about this. I think if they'd just been more forceful at that point in time. Or the other thing that I've mentioned many times is that if Lucy had accepted, I can't go back onto that unit. If I have to give up my career in nursing, so be it. But I've got to go for constructive dismissal. There is no conceivable way I can go back into a working environment where people have accused me of murder, and those people are still working there. So either the executives needed to play hardball with the consultants, or basically Lucy had to do the same in a slightly gentler way. And that was the only way. And what happened was, I think Ian Harvey and Tony Chambers handled it very professionally, but they just couldn't have envisaged how determined the consultants were to go to the police. And unfortunately, it blew up in their face. How can anyone have had any chance to prove they did not murder someone if there was no murder in the first place, and they are not allowed to revisit demonstrating there was no murder, as you cannot prove any fabricated evidence did not take place, when even if you were there or there is no proof against you, yet you're accused by layers of fabrication? A very good question. Of course, this is one of the problems that Lucy faces, that after you're convicted, the emphasis goes from being innocent until proven guilty to being guilty until proven innocent, and how indeed can you prove yourself innocent of something that never occurred? It's obviously a calamitous court case, a calamitous investigation. The whole debacle is a national embarrassment, and it will be spoken about and written about and talked about for centuries to come, I have no doubt. All we can do is do the best that we can to expose this and wait for the system to accept the glaringly obvious reality. The public release of this document, this is referring to the grievance procedure, also raises additional questions about the police investigation. Assuming Cheshire Constabulary got hold of this document, surely they should have realised that it raised important questions about the reliability and motives of Brearey and Jayaram, on whose claims and information they had relied initially when commencing the investigation. Did they ever pursue those questions? Well, I think the simple answer to the question is that they didn't ever pursue those questions. I think that's very clear, because if they had, they wouldn't have included Brearey and Jayaram in the investigation, as we know that they did. In terms of whether they had the document, it's overwhelmingly likely that they didn't have the document, because it's only come out in the Thirlwall inquiry very recently, and we surely would have seen it before now if this was in the public domain. But everything about the police, everything we know about the police, everything we know about their investigation, everything we know about what they said and have said publicly indicates that they wouldn't have sought something of this nature, and that they just completely uncritically accepted everything that Brearey and Jayaram told them. So they never would have uncovered this document, and they never would have bothered to comprehend how important the grievance procedure was. Lucy Letby, inadvertent whistleblower, an even more vulnerable position to be in than an intentional whistleblower, as you're not prepared for any onslaught to follow. So very fair comment. So this is referencing the remarks that Dr. Martin Pittman made about whistleblowing and about Lucy being an inadvertent whistleblower. And it did put her in a vulnerable position, as you rightly state here. And that could be very significant, as I've discussed earlier in the video. We just don't know exactly what happened, what was going through people's minds, and we'll probably never know. But it is another interesting aspect of the overall picture at the Countess of Chester, certainly. Lucy was placed in great danger as soon as she won the grievance. Indeed, the very accusation of deliberately harming babies placed her in an untenable position. I agree. Chris, do you think the case and accusations would have continued if Lucy had just quietly left the hospital, or was Brearey in his mind absolutely adamant that he had discovered Britain's most horrific child killer? At the Thirlwall inquiry, he even asserted Lucy had begun harming babies at Liverpool Women's Hospital. It is his assertions that have pushed the investigations against Lucy, including at Liverpool Women's Hospital, putting her in grave danger. Well, I think that based on the grievance document that we've seen recently, the situation probably would have disappeared had Lucy left. In fact, potentially Brearey would have been in a vulnerable position if Lucy left, because now he's facing potential disciplinary action, and the subject of all his wrath is no longer working at the hospital, so suddenly he's very vulnerable. So he probably would have just shut up if she left, realistically, let alone if there was a constructive dismissal. I do think it would have drifted away, because then the atmosphere, on the nursing unit, they would have been saying, why has Lucy left? She's done nothing wrong. No evidence has been presented for having done anything wrong. And she wouldn't be there to be the scapegoat anymore. So then all of a sudden, everything would be pointing towards Brearey. Now, Brearey's obviously in a more powerful position as a consultant, but he's just been found by the grievance to be in a position where he should be facing disciplinary action. So therefore, he'd be very vulnerable. So therefore, I think he would have kept pretty quiet. But I can't, obviously that is, again, there's an enormous degree of speculation there and we will never know, but I think it probably would have drifted away. So this is referring to the grievance again. Might it be that this document has only just been released because it was Thirlwall's intention to never release it? Could it be that outside pressure or fear of outside pressure has resulted in its release? A very good question. I obviously don't know. Again, there is definitely a possibility that outside pressure resulted in its release. We can only guess why a document that was produced 10 years ago, that would very obviously have been available to the Thirlwall inquiry, that could have been published 2 years ago, is only being published now. Ultimately, I don't think there is any acceptable explanation for that. As to what the explanation is, we can only speculate, but I think it's regrettable that a public inquiry takes so long to release documents that have been published 10 years ago. There is no reasonable explanation for it. Did the jury see this grievance document? So the simple answer to that is no. It was mentioned a few times in the court case, but there is a ruling from Judge Goss saying you're not allowed to talk about this too much and you're only allowed to talk about it in the way that I say so. So it wasn't entirely absent from the court process, but it was not allowed to be contextually discussed in a way that would have helped Lucy. Is it correct to think that had the jury seen this grievance report beforehand, they would have understood that those two consultants had an axe to grind against her to begin with, and their court testimony should have been subject to more doubt and scrutiny? I think it's quite reasonable to say the answer to that question is simply yes. It would have made a massive difference to the credibility of their evidence and the whole context of what occurred at the hospital. Moreover, if Lucy Letby had been guilty at the time of having killed those babies, why on earth would she have invited further scrutiny into her behaviour by the hospital administration? A very good question, and of course there is no acceptable answer to that question. It's just simply not the behaviour of a guilty person. And finally, question, did more babies die after this grievance procedure? And the answer to that is yes. We know that because of Daily Telegraph article that came out fairly recently mentioning that there were further deaths on the unit after Lucy was removed. Who was the medic that was around most of the time? Well, there's two answers to this question. Firstly, the medic you're referring to was one of the anonymised doctors, so we don't exactly know who it was. I think it might have been Dr. ZA, but I could be wrong about that. But it was certainly one of the doctors who was anonymous. However, I should also mention that it was stated during the Thirlwall inquiry by Dr. John Gibbs that he was around for a lot of the collapses that were originally cited with regard to Lucy. What I don't understand is, with the supposed insulin results, how come the consultants didn't know that you shouldn't use the results as being conclusive as stated by the makers of the test? The same should go to Dewi Evans and the rest of them as well. Yeah, so I think there's three answers to this question essentially. The first one is they're not specialists in that area, so they wouldn't necessarily know this. The second thing is that it's fairly clear by this stage that they're looking for more evidence to incriminate Lucy. They're not looking at things dispassionately or objectively in any way. And then the third thing to say really is they shouldn't have been looking for anything. They shouldn't have been involved. The fact that police's involvement in the investigation is beyond farcical. So that's all I can really say about that. I mean, Dr. Evans, another rare reliable statement from him where he admitted that he doesn't know the first thing about insulin. He didn't even know there was more than one way to measure it. So he just doesn't know. It's likely Brearey and Jayaram wouldn't know. Does anyone know on what legal basis Lucy Letby was held in jail prior to the trial and the guilty verdict? I'm not familiar with English law, but this feels like it goes against the general principle of innocent until proven guilty. Apologies if this has been covered before. So if you think about this, there can be people with flight risks, and for serious crimes, there are circumstances in which it can be justifiable. But I'll go over this with you now so that you know the legal basis for this. So with regard to this question, I thought this would be the easiest way to go through it rather than show you the legislation. The starting point is a statutory right to bail under Section 4 of the Bail Act 1976. So, of course, the term statutory would suggest that this is universal. However, a court can refuse bail and remand someone in custody only if one of the Schedule 1 exceptions applies. The main grounds are substantial reasons to think the person would fail to surrender, commit an offence while on bail, interfere with witnesses or otherwise obstruct justice, or that custody is needed for their own protection in limited cases. Courts are also meant to use custody only where bail conditions would not be enough to manage risk. And then he goes on about certain statutory restrictions and so forth. So if you look at those conditions, we would look at them now and think, well, Lucy doesn't fit under any of those conditions. It's very unlikely that she's a flight risk. She's not going to fail to surrender or anything like that. And she's not dangerous anyway, not physically dangerous. Very unlikely she's going to commit an offence while on bail, given the nature of the allegations and given the fact that she hasn't done anything. Why would she, in the 2 years that she's since she was first arrested? She can't. I suppose that you could say it's not inconceivable that she could interfere with witnesses, but it's pretty damned unlikely. And she can't obstruct justice in any other way. I suppose you could argue that custody is needed for her protection, but I'm sure that wasn't the reason that she was denied bail. So I just simply asked the question, why would this have occurred in the Lucy Letby case? And it's stated here, in Letby's November 2020 hearing, she was charged with 8 murders and 10 attempted murders, and the reporting says her solicitor made no application for bail. She was remanded in custody. In England and Wales, bail is not automatic. The Bail Act 1976 lets a court refuse bail where these grounds exist. For a charge of murder, and of course multiple murders here, there is an even stricter rule. Under the Coroners and Justice Act 2009, bail may not be granted unless the court thinks there is no significant risk that person, if released, would commit an offence causing physical or mental injury to another person. So once Letby was charged with multiple murders, remand in custody was legally very easy to justify. So I'm going to show you as well now some extracts from a Guardian article of the time. So this is what was reported by the Guardian when Lucy was denied bail. A nurse accused of killing 8 babies at a hospital neonatal unit has been remanded in custody after appearing in court via video link. Lucy Letby sat at a desk behind a solicitor and only spoke at the 12-minute hearing to give her name, address and date of birth. She also faces 10 charges of attempted murder. Letby, 30, is accused of murdering 5 baby boys and 3 girls at the County Chester Hospital in Chester, where she worked. The District Judge Nicholas Sanders, sitting at Warrington Magistrates Court, imposed a Section 45 order preventing the press and media from identifying the alleged victims of attempted murder, 5 boys and 5 girls. All the offences are alleged to have been carried out between June 2015 and June 2016. Letby's lawyer, Richard Thomas, made no application for bail as he sat beside her throughout the hearing in a police station in Chester. The nurse from Hereford was originally arrested in 2018 and again in 2019, but was bailed pending further inquiries. She was re-arrested on Tuesday on suspicion of murdering 8 babies and attempting to murder a further 9 as part of the investigation into the County Chester Hospital, which began in 2017. Only 2 members of the press were allowed into the courtroom. A dozen more in an annex courtroom next door watched via video link. Families of the victims were also watching the proceedings via the same link at remote locations. Neil Fern, the chief executive of Prior's Solicitors, who was representing some of the families, said they welcomed the decision to charge Letby, describing it as a significant step forward. The families are overwhelmed with the news and there is a mix of emotion. All the families now have hope that they can finally start to learn the truth of what happened in the first days of their children's lives, Fern said. We have been working with the families for many years on these cases and they have had to live with the consequences for all that time. Robin Smith of Slater and Gordon, representing two of the families, said, "Our clients are relieved that we are one step closer to getting the answers they have long since been waiting for. We await the outcome of the criminal proceedings and will of course be supporting our clients through this traumatic process." So immediately with regard to that, you can see the extent to which the families have indeed been dragged through this process that is described here rightly as traumatic. And it's awful to look back at this now and realise it's now 9 years since they were first informed that there were suspicions regarding the way that their infants had either collapsed or died. And the chances of them ever coming round, any one of them coming round, is very slim, because they've been dragged through this traumatising process by the fact it was referred to the police in the first place, the police themselves, and the solicitors and legal teams that have represented them. And it is tragic to look back at this and read this again. And I'll make further reflections after I've just read this final portion. Sanders said there should be no audio or video recordings of the proceedings. The court clerk then dialed into Blackham Police Station, Chester, to see Letby, partly shadowed, waiting for proceedings to begin. The judge, addressing the defendant, said, "Today's court hearing is for a number of matters. I won't be taking any plea today, as I'm sure Mr. Thomas has discussed with you. These are matters allocated to the Crown Court. Today is a preliminary hearing to send to the Crown Court." At the end of the hearing, Sanders told Letby she would have to make a physical appearance at her next hearing, which was due to be at Chester Crown Court on Friday afternoon. The nurse, who at the time of the alleged offences was living in Blacon, was arrested in Hereford, where she spent her childhood and where her parents still live. That was because she was banned from living in her own house. DCI Paul Hughes, who is leading the investigation, said following her arrest, "Parents of all the babies have been kept fully updated on this latest development and they are continuing to be supported throughout the process by specially trained officers." So in addition to what I've said already, I want you all to reflect on, look how much was stacked against her. Look how one-sided that report is at that time. Look how little we hear from Lucy, or how little we hear from her solicitors, or how little we hear about her side of things. All we hear is all of these powerful bodies stacked up against her. It's an awful thing to read back on, and I guess that answers your question pretty fully. But I just wanted to read this out and just show people what happened at the time of Lucy Letby being refused bail. If the police thought they were correct, why did they exclude certain members of the press? Why are they continuing to provide obviously biased information to the press? So I'll be going into this in more depth in a future video, probably the next video that I post. It's obviously wrong of them to exclude certain members of the press. I think most of what they did at that press conference is not out of the ordinary. I guess the exclusion of Peter Hitchens, according to his own account, which I have no reason to disbelieve, is completely wrong. The police should not be selective in the way that journalists admitted to a press conference, but I've not heard of anyone else being excluded. That doesn't mean that they weren't, but I don't know the full details of who was allowed to be there and who wasn't. Typically, anyone with press credentials should be present, and they can certainly be criticised for that, but that doesn't mean that they didn't believe that they were correct. In terms of what they're doing now, I'm sure some of them, many of them, certainly the leading people, will still be deluding themselves that they are correct, even though they're very obviously not correct. But they know they're under pressure now, and they know that their narrative is beginning to fall apart. So, in my view, that informs everything that they do at this point in time. But I would draw a distinction between the time of the conviction where they thought they were going to get patted on the back, which they were. They probably thought they had a shot at winning awards, which they did. And they probably thought, we're going to be everyone's big heroes for catching this horrible woman, and our investigation's been great. One of the things, the great tragedies of the world is, you can't make stupid people understand that they're stupid. You can't say to them, look, I know this is your opinion, I know you've got an opinion on this, but like, you're stupid, so you're going to have a stupid opinion a lot of the time. You know, that we've seen the calibre of intellect of those involved centrally in Operation Hummingbird. So at the time Lucy was convicted, they probably all believe fully, we've done a great investigation, aren't we wonderful, bring on all the plaudits and all the praise and all the rewards and accolades and all the rest of it. And they just had no idea, even though I watched their film. That's why they put the film out. But I sat there watching the film and I could see all the problems with the investigation, all the mistakes they'd made. But I don't think I'm blowing my trumpet very much to say I'm more intelligent than them. So that's why I can see it, and they can't see it. So although they shouldn't have excluded Peter Hitchens or any other members of the press, that doesn't mean that they didn't think they were correct. I'm absolutely certain they thought this was a rock solid, very safe conviction in which they had behaved with scrupulous professionalism and done all the right things and done a great investigation and caught someone who was doing something awful. And of course they became too emotionally involved with the families, and that emotional aspect of it has further clouded their judgment. They're just not very bright ultimately. Great interview, thank you both. Since Daniel Stonier was the family liaison person and so involved in questioning Lucy, does this bring into question the claim by Cheshire Police they kept a sterile corridor in how they investigated each case? I'm not sure. The problem with the sterile corridor is they handed loads of information to Evans, thus rendering the sterile corridor meaningless. But I think it's not so much that it calls into question the sterile corridor, but it calls into question the objectivity of their investigation, in my view. That their investigation became altogether too emotional, and that has clouded their judgment quite significantly. And finally, just watching live, what is the thinking in the investigation notes not being available after conviction? Well, I'll put this question to Dr. Steve Watts in the future, and he'll no doubt give a much better answer than me. It seems to me there's some likely procedural reason for this. I'm fully in favour of major police investigations being as transparent as possible. There may be circumstances in which certain documents cannot be made public, but wherever possible, I'm always in favour of transparency. Typically, powerful organisations and powerful bodies are not in favour of transparency because they don't want to be held to account. So typically that, overall and overwhelmingly, that is why investigation notes are not made available, because the police want to retain their power and they don't want to be held accountable. We've seen how accountable Cheshire Police consider themselves to be and how much they will fight any form of public accountability or public scrutiny. That's perfectly normal. That's normal for any powerful body or any influential body or any body that's in a privileged position. It's just a very typical self-serving act that these sort of bodies will engage in. So I hope you found this enlightening and useful. Thank you for all the support. As I say, I've reached 7,000 subscribers. The road to 8,000 subscribers has already begun. And I'll look forward to receiving your comments, queries. Please do leave your questions. I have less time to collect the questions from now on, so the gap to the next Q&A session may be longer than this one, but I'm sure there'll be a 14th edition of this soon. And thanks again for watching, and I'll look forward to reading your comments.